Welcome to The Advocate's Voice, Personal Injury with David Maran.
Welcome to The Advocate's Voice with David Maran and John Clemence. With more than 30 years in the courtroom, and David's here to help guide you through the confusing world of injury law, one conversation at a time. Today's episode is a bit of a part two because we're going to go back to a difficult issue we talked about on the last episode, wrongful death. So David, thanks again for hopping on the call.
I'm glad to get an opportunity to kind of finish this topic. It's very complex and it's very technical as well, but it's understandable when we break it down.
And very important too. And so for those who maybe didn't watch part one and they're just now coming into part two, can you just give us a recap or a kind of an overview of what wrongful death even means and how it is maybe different than, other types of personal injury cases?
I'm going to try to explain the basically two actions that are brought or causes of action at the same time in any complaint that you or the lawyer file. One is for survivorship damages. The second is for wrongful death. It's very easy to understand. Any conscious pain and suffering that your loved one may have endured up until the moment of their death is all covered by the Survivors Act. And that means that you had to experience those things during your life before you passed away. And so that the value of that claim combined with the rest of your assets go into your estate and then are distributed to the people entitled to receive them by virtue of your will or something called the intestate statute, if someone doesn't have a will. And as I mentioned in the first episode, one of the things that we'll talk about is things that you might need to do right away to take care of business, to do what you need to take care of your loved one, get them buried properly. And one of those things is contacting the probate court. And the probate court will help you set up the estate and help you with distributing everything properly to those people who are entitled to receive them. Now, outside of probate and running directly to the actual dependents, the people who really received that time, that attention from their lost loved one, they are entitled to receive under the Wrongful Death Act. And that claim runs directly to them and does not go through the estate. And what is that claim? We talked about the loss of any money, of course, that might have flown to you, as if your parent was providing educational money, for example. But things like companionship and guidance and little things that they did for you, whether they cut your grass or fix something in your house. The court has created a way we can calculate those losses because they had to. Because in New Jersey, we don't allow recovery for the loss of the love or of your grief following the loss of your loved one. That is, we consider priceless. And we, among most states, don't permit those claims. So the court fashioned a remedy to allow us to calculate damages in a way that can be replicated, duplicated, done again and again and again. And what do I mean by that? Well, if you lose the companionship of your spouse, you may spend 1,000 or more hours a year with them. The court allows you to seek recovery for the purchase or hiring of a companion, like you'd have for an older person. No one actually does that, but gives you a way to calculate your losses, to add into your lawsuit those values of what you lost. So we have the survivor's claims, which is any conscious pain and suffering from the moment of death. From the moment of death forward, those claims are now those of the actual dependents, maybe the children, the spouse, a sibling, a parent. Those would be considered actual dependents, and the damages are calculated as we just spoke of.
I have a question about that because you say there's that line of demarcation, right? There's the suffering leading up until the time of death and then after death. So those are different cases. Does that literally mean you if I had to go through this, I would be involved in two separate potentially two separate court cases? Are they that far apart, or is it something you can do together?
You put them in the same lawsuit, and
Okay,
they're merely pled separately. So
I see.
it could be count one and count two of the complaint, which is filed. But you do split them up because they're very different theories, and they have a different class of people who receive the benefits. And that's just simply the correct way of pleading the case. So, for example, if it was a case involving some negligence and some violations of the products liability laws, those would be pled separately. If it were something that might include strict liability of any form and also negligence, they would be pled separately. Different recognized ways of presenting a claim should be pled separately. That way, it's most understandable by the court.
I see that. Okay, that makes a lot of sense. So I think the main takeaway from this part of the conversation is call you if I find myself in that situation, because that's a lot
There's a
of
lot we
details.
can do. If you've lost a loved one, there's a lot we can do. And
Yeah,
right in the beginning, it's just trying to help guide you through the basics that you're already undertaking. The families are great. I mean, they know they have to bury someone, but they may not know that there might be an opportunity to ask for an autopsy, or that they really need to contact the surrogates or probates court to take care of setting up the estate for their loved one. These are things the attorney can remind them. Simple things. So you don't go to the probates court until the funeral director has given you a death certificate with a raised seal. You don't go to the probate court until you've dug up the original will, assuming you can find it. The original and latest, most recent will you bring with you as well. But if you have those two documents, it's a good time to go visit with the probates court, and they can guide you towards setting. Where would you go? In the county where the person passed away. So here in Essex County, New Jersey, you'd go into Newark. There's a brand new building on MLK Boulevard for the surrogates court, and they have a wonderful facility there and great parking.
nice. And you, not to downplay it, but you say, well, just even simple things like make sure you get a certificate of death before you visit the probate court. And I know when I'm under stress and I have someone who can just tell me, okay, John, just do this thing. Like there's some comfort and control in that. So I don't want to discount simple as being like not worthwhile. Like I can only imagine having, trying to bury someone and not knowing what to do, to have you come along inside and just say, okay, I just need you to do these three things. Like, okay, I can do those three things. So I think that's a valuable service that you provide.
It'll let them concentrate on what's important, gathering
Yeah,
the family, making the right decisions on a religious service, doing what it will take to start healing the family. The
absolutely.
law part of it, I'm just allowed to bring out those pointers to make sure things go smoothly. My real job is going to then be to gather all the evidence, try to find where fault is, and start to do the investigation.
Yeah, and I can imagine trying to, do that on your own while you're trying to, bury a loved one. So yeah, totally appreciate the value you bring. And I did have a follow-up question though,
Sure.
is when we're talking about this, who exactly can file a wrongful death lawsuit? And like, what are the requirements that you need to know about to initiate a claim?
All right. If the person has a will, they've named an executor in the will, and that person has a right, for example, to bring that claim. Many times, though, you have families that the person has not written a will. And if they've not written a will, there is a statute, which is a passed law signed by the governor, called the intestate statute. And it tells you who gets what. And let's say there's a spouse. Well, spouse would then have the first right of being, at this point, an administrator, right? So an executor if there's a will, an administrator if there's no will. And If it's a spouse, they have first entitlement. They go in with those documents and it's set up. If it's the loss of a parent and that parent was divorced or widowed or widower, then the children go in together. Usually my advice is all go in together. Probate will explain it to you. Essentially what's going to happen is you'll have to choose among you. Generally, it's best for one person to be agreed upon by the siblings to be the administrator of the estate. And you're all there at the surrogate's court. The surrogate's court will help you prepare what's called a renunciation in favor of the chosen sibling, whether it's the whoever it is. I've seen all combinations. The one I remember most recently was the youngest sibling who was chosen. But that person only speaks for the family. It doesn't change or affect who receives what amount of money. It just gives me the person who is named with the authority to make decisions on the case. Ultimately, the court would prepare what's called a distribution order. And a distribution order is done after a full hearing with obviously complete evidence as to why someone might be entitled to a certain percentage or amount of a proposed settlement. If the case is tried, the judge will most likely put on the jury verdict sheet separate questions for what each actual dependent would receive from the wrongful death portion of the case. In a distribution hearing, often the families agree in advance, and we present all the evidence to the court, including testimony, and the court would then either grant it or make some alteration and then grant it then. The distribution order basically says who gets what. What is it based on? Well, if it's a settlement, the attorney has undoubtedly used their economic report. And their economic report is a calculation within the way the statute prescribes acceptable methods of damages. The companionship, the guidance, the things that are allowed by our wrongful death statute. The economist will, based upon the deposition of the clients, generally a long interview, they will make a calculation of what their losses are. And it will be comprised of the things generally that they did with your loved one while they were alive. So if a husband and wife were together, a certain number of hours per day, per week, per year, that would go into those calculations. If we're talking about a child who lost their parent, well, certainly there's a ton of time that they would have spent with their parent, as well as a large income flow, schooling, clothing, food, so on, that child would likely have received from their parent. And the economist would calculate all these things. If there were a trial, the economist would get on the stand and explain all these things to the jury and do all the calculations so that the jury could follow how they reached this particular number. And then if the settlement was less than all the combined numbers of all the actual dependents, for example, there were 4 children and they lost a parent, the economist will evaluate each child separately based on their losses. And of course, there'll be a gross number. If the settlement is for less than that, it could be proposed that the split is in proportion to what the original economist report said. It could be something else that the children agree upon. The children are entitled to demand the hearing, to demand that the proportions hold up, or that the court evaluate the claims after hearing all testimony, including that of the economist, and then deciding on their own what is appropriate. But it's got to be based in reality. I mean, if you have, let's say, 2 children who lost their mom, but one child had been estranged from her mom for years, and the other child has a family, and the mother was there several times a week, had dinner with them, babysat. Remember, if we take the loss of love, the loss of grief, or the cost of the grief out of the equation, and we're only allowed to calculate damages based on things which the statute finds compensable, things that can be equated to money, loss of companionship, loss of guidance. And that didn't occur for the sibling who was estranged. Now, of course, that sibling would have rekindled that relationship. And the question is, well, when would that have occurred? And would it be as full and as much time as the brother who the mother was already spending tons of time with? So it's likely that the economist's numbers would be more heavily weighted to the brother as opposed to the sister. The sister could demand still her hearing. She doesn't have to agree, but ultimately the court will decide, if they can agree, what the correct distribution is. But the case should result in a distribution, hearing, and then order, so everyone knows what the appropriate split is and have the court's order and approval on that split. That's how the case is finished. Yeah.
Yeah. So that's just a great overview. And David, time's been flying by. We already have to wrap it up. I feel like we just started. But thank you.
It's a long issue. It
is, but it's
so many ins and outs of it.
It is, but it's interesting, and it's also important, especially for our listeners who are going through this, trying to figure out what to do. So thank you so much for sharing of your wisdom and just your years of experience today.
Thank you very much for having me.
Absolutely. And thank you to our listeners for tuning into The Advocate's Voice with David Maran and John Clemence. We do hope today's conversation helps shed light on what to do and what not to do in a wrongful death claim. So if you or someone you know or care about has been involved in a personal injury situation, don't wait. Visit njmalpractice.com to learn more or to schedule a free consultation with David and his team. And as always, subscribe to The Advocate's Voice for more real talk and trusted legal insight from the courtroom to your corner of New Jersey.
Thank you. Good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.